In what's being described as a constitutional crisis and violation of the law in a New York Times bombshell report, Trump's attorney general is being accused of illegally attacking a federal judge considered to be an enemy of Trump's, and I have all the unbelievable details coming up next. Normally when I share an article, I curate the highlights in the interest of time, but in this case, I'm sharing most of it because the details by the authors, Nancy Gertner, a retired federal district court judge, and Stephen Vladeck, a professor at Georgetown University Law Center, are so important to what's at stake for our democracy, it's worth the longer than usual read. It begins with the headline, "This attack on a federal judge is preposterous."
Last week, in a post on social media, Attorney General Pam Bondi announced that the Justice Department filed a misconduct complaint against James Boasberg, the chief judge of the federal district court in Washington, claiming he made improper public comments about President Trump and his administration. The essence of the complaint is that Judge Boasberg, in talking with John Roberts, the Chief Justice of the Supreme Court, and other federal judges, said things that have undermined the integrity and impartiality of the judiciary, and that as a result, he should be subjected to an investigation, temporary reassignment of some of his cases, and, potentially, public reprimand and consideration of impeachment-related recommendations. The complaint misrepresents both what Judge Boasberg said and the nature of the setting in which he spoke, and it misapplies the law and the rules governing judicial conduct. Worse, it is a dangerous escalation in a mounting list of assaults by the current administration on the legitimacy of the federal courts. It is, in a word, preposterous. According to the complaint, the comments took place on March 11th at a session of the Judicial Conference of the United States, the national policymaking body of the federal courts. In that session, the Justice Department claims Judge Boasberg, straying from the traditional topics of the conference, expressed his belief that the Trump administration would disregard rulings of federal courts and trigger a constitutional crisis. The Justice Department claims that Judge Boasberg tried to push a wholly unsolicited discussion to persuade the Chief Justice and other federal judges of his preconceived belief that the Trump administration would violate court orders. Apparently, the complaint is based on a leaked memorandum, reportedly written by a member of the Judicial Conference. Even if the claims against Judge Boasberg had merit, they don't. The Attorney General's announcement on social media is a violation of the law, which requires confidentiality. The entire exercise is an insult to the federal judiciary and cannot stand. If Judge Boasberg was accurately relaying his colleagues' concerns, the complaint was tellingly silent on this point, then he was providing appropriate feedback to the Chief Justice, not opining on a specific pending matter. The notion that it is somehow improper for judges on lower federal courts to raise a general concern about the prospect of their orders being ignored simply beggars belief, and it turns out that those concerns were well taken. In July, the Washington Post reported that Mr. Trump and his appointees have been accused of flouting courts in a third of the more than 160 lawsuits against the administration in which a judge has issued a substantive ruling last week. The Times reported on the Senate confirmation of Emil Bove, a Trump loyalist, as a federal appeals court judge, noting that, during his brief tenure as a Justice Department official, Bove was accused by a whistleblower of having suggested that department lawyers might defy court orders. In a Senate subcommittee hearing, Ms. Bondi seemed to suggest that the administration will follow court orders, but only those of the Supreme Court. Finally, even if Judge Boasberg's comments had been public, even if the comments reflected his views, rather than a summary of his colleagues' concerns, and even if those concerns weren't well taken, the Justice Department's complaint doesn't come close to making the case that he violated the Code of Conduct for federal judges. As the complaint notes, Judge Boasberg did later grant a temporary restraining order in JGG v. Trump, but that was a ruling on the specific facts and applicable law in that case, the job of a judge. It doesn't mean he was predisposed to rule against the administration. The real issue here is why Ms. Bondi decided to make such a spectacle out of an obviously frivolous complaint against a highly respected federal district court judge. It seems clear that her first intended audience is other district judges. For them, even frivolous judicial misconduct complaints come at a personal and professional cost, especially when they are filed not by private litigants, but by the Justice Department. If the chief judge of the federal district court in Washington can come in for such treatment, perhaps other judges will think twice before raising legitimate concerns. The federal judiciary, like Congress, is a co-equal branch of government. Part of its job is to serve as a check on the executive branch. This is so with respect to federal judges across the country, no matter who the appointing president was. Rather than reflecting the lawlessness of the courts, if the complaint against Judge Boasberg is, as it appears, an effort by the Justice Department to baselessly muzzle him, that would be lawlessness coming from the executive branch. The second audience is, without doubt, Mr. Trump and his supporters. By all appearances, the complaint furthers the idea that presidents can do what they want without a care for federal judicial rulings, That's not how our legal system and Constitution work. Ms. Bondi wrote that Judge Boasberg's comments have undermined the integrity of the judiciary, and we will not stand for that. The way to look at this is the inverse. Her Justice Department is attempting to undermine the integrity of the judiciary and the rule of law.
Again, here's what the article looks like if you want to read it in its entirety at the New York Times website. And let's remember, it was penned by a retired federal district court judge and a professor at Georgetown University Law Center. It doesn't get any more alarm sounding turned up to 11 than that. This is not just a petty political squabble or some routine mudslinging. This is Trump's handpicked attorney general weaponizing the Department of Justice against the gatekeepers of our democracy. If this doesn't send a chill down your spine, you're not paying attention. Trump's White House is not hiding it anymore. They are openly trying to intimidate judges into silence so lawlessness can go unchecked and run amok. And if Bondi and the other outlaws succeed, the message is loud and terrifying. Defy Trump and you'll be destroyed. Our founders built an entire system to prevent exactly this kind of misuse of power, and yet here we are. So what is the limit of Trump's strongman style of tyranny, and is there a government solution for shutting it down? It is very alarming that at this moment in time we have far more questions and concerns than answers. I'm Dan. Thanks for watching. Please leave your thoughts with a comment below, and let's continue to occupy democracy together.
I hate Occupy Democrats.